everybody is very concerned with the question of payment of wages to employees without doing any work. Now, there is an act to be considered, and there is also the various circulars and advisories to be considered. Before I go down to the circulars and advisories, I think it might be better for me to point out the charging section under which this action has been issued. The main advisory with which we are really concerned today is the advisory of 29th March 2020. By this advisory, it appears, and I say appears advisedly, that the government wants industry of all kinds, even the smallest shops and commercial establishments, to pay full wages to their workmen. The question is, does it really do that? Second thing is there power in the government to direct payment of wages by an employer, even though there is no work going on? Now, just as an aside, I may point out that when an earlier petition was filed in Supreme Court, workers had filed an intervention application. They filed one today also. And in that, their case was, okay, this is a contract, and a contract is absolute. And that so long as a contract subsists, wages must be paid. However, in my opinion, this ignores the fact that the definition of wages under the Industrial Disputes Act and the Payment of Wages Act refers to payment of an amount in lieu of or in consideration of work. So therefore, by its very definition, wages means wages for work done. Now, if an employer locks out his employees or lays off his employees, the position is different. But in a situation like the present one, where the employer is unable to work, then to my mind, it is not a question of payment of wages. It would be a question of payment of a charity or an ex gratia amount, which the Disaster Management Act does not, in my opinion, contemplate. Having said this, let's go straight to the Act. There are several provisions dealing with the Executive Committee, the National Plan. We are not today concerned with that. Today, we're really concerned with the power under which the government has acted. Now, when I say government, in this case, I mean the government of India and the notification of 10th March 2020, which is the foundational notification on the basis of which the government is acting. Now, this notification on a closer perusal indicates to my mind that it applies only to migrant workers. If you see the advisory, it refers to the fact that it is necessary to protect the interest of migrant workers. And in that context, this advisory has been issued. What is confusing is at the bottom, there is a simpliciter statement that all employers shall pay. But in my opinion, when you read a document, you don't read a document half and half. You read it in totality. So if the principal part of the document refers to migrant labor, then in my opinion, the secondary part where it says all employers and all employees must also mean migratory workmen. Now, the fact that this notification does in fact, or this advisory does in fact refer to migratory workmen is borne out by a subsequent circular of the Ministry of Labor and Employment dated 30th, one day later. And in this subsequent letter or advisory, whatever one calls it, they have said very clearly that we have also, and I quote, we have also witnessed a large number of fleeing migrant workers out of panicky, which has further added to their miseries. Because of this unfortunate happening, the Home Secretary, Government of India, New Delhi, has issued OM number so-and-so dated 29th March under Disaster Management Act, wherein it has been advised to all state governments, union territories, to ensure adequate arrangement of temporary shelter and provision for poor and needy, including migrant workers stranded due to lockdown. Therefore, my earlier opinion that the circular or advisory of 19th March relates only to migrant workers is, in my opinion, borne out by this subsequent document of the very next day. Therefore, I am of the opinion, and that's what I will be arguing in the Supreme Court when this matter again comes up. This circular cannot be the foundation for payment of wages to regular workmen also. Whether payment of migrant workers is constitutionally valid is another issue which I will deal with. But the first point is, does this foundational circular or advisory govern ordinary, regular workmen of the company also. Now, in this context, it is interesting to note that the Ministry of Corporate Affairs issued an answer to a series of FAQs. This was done as late as in 10th April 2020. Here, there are 2 or 3 questions which were asked, the answers to which are very material. The first question was whether payment of salary, wages to employees and workers, including contract labor, during the lockdown period can be adjusted against the CSR expenditure of the companies. The answer is payment of salary, wages in normal circumstances is a contractual and statutory obligation of the company. Similarly, payment of salary, wages to employees and workmen even during lockdown is a moral obligation of the employers, as they have no alternative source of employment. So you will notice that they themselves are here saying that it is a moral obligation and not a statutory or contractual obligation, which, as the earlier part says, is the norm. Thereafter, in query number 6 here was whether payment of wages to casual daily wage workers during the lockdown period can be adjusted against the CSR expenditure of the company. The answer is payment of wages to temporary or casual or daily wage workers during the lockdown period is part of the moral, humanitarian, contractual obligation of the company and is applicable to all companies, irrespective of whether they have a legal obligation for CSR contribution under Section 135 of the Companies Act. Hence, payment of wages to temporary, casual, or daily wage workers during the lockdown period shall not come towards the CSR obligations. Next question asked was whether payment of ex gratia to temporary, casual, daily wage workers shall qualify as CSR expenditure. And the answer was, if any ex gratia payment is made to temporary, casual, daily worker over and above the disbursement of wages specifically for the purpose of fighting COVID-19, the same should be admissible to a CSR. Now, therefore, if we read the circular of 19.3 together, sorry, 29.3 together with 33 and with this FAQ, it is, to my mind at least, clear that whatever the government has done up to now is with regard to migrant temporary casual workmen, and that it would not on its own apply to regular workers. Having said that, I'm of the opinion that in any event, such a power, even with regard to migrant workers, does not flow from the Disaster Management Act. The Disaster Management Act, to the extent relevant, is Section 10. Section 10, I mean, this order has been issued under Section 10, subsection 2, and it's rather unclear whether it is subsection 2L or whether it is subsection 2I. But it bears mentioning, or bears considering both. If you see the Act, and you go to section 10.2, you will see that it is not possible for the government to utilize that power for the purposes of issuing an advisory of this nature, whether for migrant workers or for regular workers. The order says it is issued under 10.2, and as I said, it's not clear whether it's L or I, but let's take them both. 10.2I refers to evaluate, gives them the power to evaluate the preparedness of all government levels for the purpose of responding to any threatening disaster situation or disaster, and give directions where necessary for enhancing such preparedness. So, evaluation and directions for enhancing such preparedness. That is 10.2I. 10.2L says lay down guidelines for or give directions to the concerned ministries or departments of the Government of India, the state government and the state government authorities regarding measures to be taken by them in response to any threatening disaster situation or disaster itself. So therefore, in my opinion, there is nothing in the aforesaid Act which in any manner permits the government to issue such a circular or an advisory. I must also caution you that there are a whole series of other advisories and orders issued by the various departments of the government. All of them need to be carefully studied. You will notice from them that the majority of them are either in the nature of a direction to the government to issue an advisory or in the nature of an advice itself. None of the other circulars issued are a direct order to pay these wages. Having said that, What have we covered? We've covered the fact that the government itself looks upon it as a liability towards temporary casuals, and that as far as even this lot is concerned, it is considered not a legal obligation but a moral obligation. We have also considered just now that under Section 10(2), there is in fact no power, in my opinion, to direct the private employers to pay the said wages. Having said that, that is the legal challenge. There's also a constitutional challenge here. You see, under Section 14, or Article 14 rather, of the Constitution of India, an action which is arbitrary, an action which is without authority or force of law, is also called arbitrary. So if the statute in issue does not, as I mentioned just now, confer power on the government to direct employers to pay wages to workmen during the period of a lockdown, then to that extent, it is an unreasonable exercise of power. Now, in the petition that was filed today, in the case of Ludhiana, in the Ludhiana matter, the first challenge is to the vires of 29(3). The second challenge is to say that if necessary, if you uphold the validity of 29(3) itself, please read it down as not being applicable to ordinary, direct, regular work under the company. These are the two challenges there. But the Article 14 challenge is that it is unreasonable. Why? Because there is no power. An action without power is arbitrary, an action which is unsustainable. It is also arbitrary and discriminatory for another reason. The other reason is that you have micro industries, you have small industries, medium and large. You cannot, in my opinion, lay down a uniform principle for all. A very large establishment having large reserves may be able to pay wages for a month or 2 months. But a micro industry or a small industry, even a medium industry, would find it almost impossible. And I have always mentioned that economics has no place for philosophy. There's no place for political philosophy, nor is there a place really even for sympathy beyond a certain limit. Ultimately, the employer or industry, if I may say so, is the engine which drives the entire economy. If you compel industry to pay wages without earning wages, or without earning income, sorry, you are ultimately going to lead to those companies closing down, and it will be a collapse of the entire industrial scenario in India. That leads us to Article 19. Article 19 provides the right to carry on business, subject to reasonable restrictions and classifications. Now, it is my submission that to issue an order which has the effect of directing the party to do something which will ultimately lead to its closure is an action contrary to my right to carry on business. You can restrict business. Remember, no fundamental right is absolute, not even the right to life. A person who is a criminal, who is a murderer, can be executed. So even the right to life is not absolute. But it is always subject to reasonable restriction. And to impose such a restriction upon management, to insist that they should pay wages even if they don't earn, is an entirely unreasonable imposition, and to my mind also violates Article 19. You also have another article which can be considered not a fundamental right, but a constitutional right. It's Article 300, capital A, which says that you cannot take away a person's property without due authority of law. Now, money has been held to be property. So you cannot take away property without due and valid law. And in my opinion, such an imposition upon management to pay wages is, in the first instance, contrary to the power. In any case, even if the power was there, it is an unreasonable power, it is an arbitrary power, and it is a discriminatory power. For all these reasons, in my opinion, that this particular notification, if it is to be read in the manner the government wants to read it, and that is in fact the manner in which they read it, because dealing with the Ludhiana matter, we were dealing with a notification issued by the state of Punjab. And in that, similarly, there was an order or direction. And interestingly, the Chief Minister of Punjab, Mr. Amarinder Singh, wrote a letter to the Prime Minister saying that please correct this, because if you insist on carrying on with this, you will bring companies to insolvency. So even the ruling class has understood that this cannot continue. There has to be some method, something found out, some way in which this can wages of the workman, or at least the sustenance of the workman, can be maintained. Now, in this context, it is relevant to note that under the statute itself, there is provision. Section 24 of the Act refers to the powers and functions of the State Executive Committee in the event of a threatening disaster situation. And subclause D provides or says that there is power to provide shelter, food, drinking water, essential provisions, healthcare and services in accordance with the standards laid down by the national authority. More importantly, you have section 38D, which provides for allocation of funds for measures for prevention of disaster, mitigation, capacity building and preparedness by the departments of the Government of India in accordance with provisions of the state plan and the district plan. So the Act itself imposes an obligation upon the government at various levels, A, to look after the food and shelter, and B, there is provision for allocation of funds for measures of prevention of disaster mitigation. There is also another interesting provision out here, which is section 46 to 50. 46 of the Act says that there can be, that there should be a National Disaster Response Fund. The central government may, by notification of official gazette, consider a fund to be called the National Disaster Response Fund for meeting any threatening disaster situations. Then it says the National Disaster Response Fund shall be made available to the National Executive Committee to be applied towards meeting the expenses of emergency response, relief and rehabilitation in accordance with the guidelines laid down by the central government. Section 47 refers to National Disaster Mitigation Fund. The central government may, by notification of the official gazette, constitute a fund to be called the National Disaster Mitigation Fund for projects exclusively for the purpose of mitigation, and there should be credited thereto such amount which the central government may, after due appropriation made by Parliament by law in this behalf, provide. Section 48 provides the establishment of funds by the state government, and one of these funds is the fund to be called the State Disaster Response Fund. And 49 of the Act says allocation of funds by ministries and departments. The reason I'm reading this to you is that it is not permissible for either the labor or for the government to say that it is the obligation or the responsibility of the employer to look after his employees in this situation. The employer is also going through the same situation. It is not only the employees who are going through it. The employer, as much as the employees, is going through an unforeseen situation. It is unfair to say that despite the fact that you have the capacity to raise funds, despite the fact that you should have raised funds, this is the Act of the 2005 Act. They should have raised these funds and they should have kept them. But the point ultimately is when these powers exist with the government, it is for the government to look after these workmen and not for industry. Industry itself is suffering. From where will industry get these funds? And if industry doesn't get these funds, then industry will close. Because ultimately, at the end of the day, you can only take out so much water from a stone. At the end of the day, you can't take out water from a stone more. Therefore, unless the government realizes this, the intention of giving food and wages to workers at this stage will destroy all capacity of workers to get wages in the prospective future. Now, I was talking to you about the Supreme Court. In the Supreme Court, there were two petitions filed, both of them drafted and filed by Mr. Abhay Nev, the advocate. And the first one was withdrawn. The second one, together with two other petitions, came up for hearing this morning before the Supreme Court. Interestingly, the Association of Newspaper Employees came to the court to say that whereas under 29(3), they were supposed to be paid regularly by the employer. The employer was not acting thereunder, and the government was doing nothing to enforce it. Our petition was to the exact contrary. Our petition was that this notification of 29(3) relates only to migrant workers. It has no connection with regular workers, and even otherwise, even for migrant workers, it is unfair, discriminatory, and violative of 14, 19, and 300 capital A. At this juncture, interestingly, the court had occasion to mention to the Solicitor General that it is not possible for an employer to continue making payment when they don't earn. This was the enlightened view of the apex court itself. Now, whereas notice was issued in the workers' petition, the learned Solicitor General pleaded, you don't issue notice here, but I will file an affidavit. So the court said, all right, you file an affidavit telling us what steps government is going to take to either subsidize industry or to provide for it. We cannot see a situation where the industry can be asked to keep paying these wages until they actually close down. So that matter has now been kept after 2 weeks. Now, there's nothing more that I can really tell you apart from what I have said just now. I am of the considered opinion at the end of the day, and as a conclusion to my talk, that the base notification of 29th March 2020 is A, not applicable to general employees or regular employees of the company, and B, is even otherwise without authority of law, contrary to Article 14, contrary to Article 19, and contrary to Article 300 capital A. To my mind, therefore, that is an illegal requirement. The fact that the state of Punjab and even the state of Maharashtra have issued directions to pay such amounts to the workers is, to my mind, equally fallacious and equally wrong. Now, I was asked earlier whether other people should join in and file petitions. It is not necessary. If you feel that you have something specific to state which has not been stated in earlier petition, then by all means, your petition will be tagged along. But as far as relief is concerned, if after 2 weeks you don't get relief, and if you stop making payment, you are liable to penal action under Section 51 of the Act. But if that does take place, then I am of the considered opinion that you should challenge that in the Bombay High Court. Don't go to Delhi because you're challenging there in the Maharashtra notification. And I would think that there is a strong reason to believe that you could sustain that challenge. I have taken up a considerable period of your time, and I have covered what I consider the essentials of the matter. There's a lot more to be said. I could have taken you through all the advisories and tell you why, in my opinion, those advisories don't take you any further. But ultimately, the only real advisory is 29th March. And to my mind, as I said earlier, that shouldn't really bother anybody else. That's all I have to say.
Thank you, sir. We have a few questions which have come in. A very interesting question which has come in is about the government's action of reducing wages or deducting salaries and wages for its own employees, but directing private parties to ensure that full wages are paid. What would you like to say about that?
That's very indicative of the correct position of law. And that is something that I propose to point out to the government. Not only the state of Maharashtra, but also I have noticed the state of Telangana has done that. They've also reduced their wages. And if I'm not wrong, the central government has refused to give the DA advance to its present workmen. There's a clear indication of the impossibility of what they're asking the private employers to do. And the government cannot and should not ask the private industry to do that which they themselves find they cannot do. There is another principle of law, the Latin phrase for which is lex non cogit ad impossibilia. The law does not contemplate the impossible. And to my mind, to ask the industry to continue paying wages without earning renders a position of impossibility. And therefore, even on that ground, this notification is not sustainable.
Another question which has come in is in the context of the principle of no work, no pay. How do you think that principle applies in the present circumstances?
If the government's notification is right, and if it is legally sustainable, then it doesn't apply. The principle of no work, no wages does not apply because the Disaster Management Act, by statutory force, compels you to make the payment. So, to put it in a nutshell, if for any reason I am wrong in my reading of 29.3, And if therefore the notification applies to all industries, and if we are wrong in our arguments under 14, 19, etc., then you have to pay. And the question of no work, no wages would not apply.
Just a couple of more questions. We have plenty coming in. Another very interesting question is, despite these notifications, could an employer enter into some sort of an agreement with an employee to defer the payment of wages? Would that be legal in light of these notifications?
Yes, I think so, because ultimately it's only workmen who are aggrieved who can seek to enforce this. I have myself advised one of my clients to enter into a settlement, if possible, with the union. Then it amounts to a voluntary reduction of wages by the workers. Then there is no imposition. Therefore, to my mind, if that can be achieved, then there is no problem.
Right. So one quick last question, since we usually take about 4 questions for every speaker. What would be the situation if these notifications were not issued? Would the employer not be bound to pay his employees, one, under the contractual obligations, two, under the other labor-related statutes which are already in place?
It would then be arguable whether industrial law does not per se contemplate force majeure, but I would definitely be in a position to argue that if I'm not earning an income, they are not working. Definition of wages, as I mentioned earlier, is payment for work done. If work is not done, and work is not done not because of my action, I have not locked them out, I have not laid them off. In such a case, if I am forced in a situation like this, I would think that the contract, like all contracts, can reach frustration. And I would think to that extent, it would lead to frustration of the contract. And I would say that then in that case, you don't pay. But short of that, you could in the first instance consider layoff. You could lay off your workmen for a period of time. And if you have a contract which prescribes that after 45 days, you can terminate services by way of retrenchment, then you can even do that under 25M. Interestingly, layoff is permissible even under 25M. Now, 25M is part of Chapter 5B of the Industrial Disputes Act. And under Chapter 5B, there cannot be a layoff, retrenchment, or closure without prior permission of the government if you are a factory, mine, or a plantation engaging more than 100 workmen. But even in such a case, Section 25(1)M says that in case of a catastrophe of this nature, the prior permission is not necessary. So therefore, to my mind, it is a sustainable argument to say that if I just am reduced to a position where I cannot pay, then the doctrine of impossibility comes in, and I don't see how workers could then demand it.
So I'll just take one last question because it's a very interesting one. What is the effect that the disaster management would have vis-a-vis other labor laws in the sense that if labor laws are providing certain protection to the employer, would the Disaster Management Act and the notifications under that override the labor laws?
See, now, this act will supersede all other acts. It's what we call a non-obstante clause. It supersedes everything. So, but it supersedes everything to the extent of inconsistency. Now, if therefore it can be argued that this act does not permit the government to impose this obligation upon the employer, if the act itself does not contemplate such an action, then it must be held that the other labor laws will apply and the non-obstante clause will not apply. I'm sorry, it's not called non-obstante clause. It's a clause under which the present statute would supersede all other acts. So if we are right in saying that the act itself does not contemplate this, or if we are right in saying that to the extent that the notification of 25(3) directs payment of wages and is therefore to be read down, then in that case, this act would not apply. The Disaster Management Act would not apply, and then all other labor legislation would automatically apply. Simple point. Does the act apply? If yes, labor laws would give way. If the act does not apply, labor laws would have full scope.
Thank you, sir. We have more than 100 questions which are lined up, but it's really difficult for me to ask you all of those, and perhaps not so difficult for you to answer any of those. So, but let me thank you on behalf of Debrief and all the attendees for coming on board and giving us an oversight about this very peculiar situation that has arisen, and wish you all the luck for your battle against this
Yes.
Supreme Court. Though, to be fair, we will try and get the Solicitor General on board and see what he has to say about all of this also.
I would love to hear that.
We will keep you posted, sir.
All right.
Thank you so much. I really appreciate it.
You're welcome.
Bye-bye. For all our attendees, as we have been doing with all the other webinars, this webinar will also be uploaded on our YouTube page. The link will be shared on all our social media pages. Thank you very much for attending this webinar. I'm sure all of us leave a little more enlightened about this aspect of the law. Thank you. Hope all of you stay safe and stay indoors. Thank you very much on behalf of all of us.